First order of business is approval of minutes from the September 23rd, 2025 meeting. Is there a motion? Okay, we have a motion and a second. Any discussion? All right, hearing none. All in favor signify by saying aye. Aye. Opposed, same sign. All right. Moving on to item 2, new business. We have an appeal of an administrative decision at 3900 Great Plains Drive. And before we start, I want to just make a brief disclosure for the record. My employer, Houston Engineering, previously prepared easement exhibits related to the properties involved in this matter. Houston Engineering is not a party to this appeal and has no financial or other interest in the outcome. I was not personally involved in preparing those easements, and the board is not being asked to review those today. I have discussed this with the city attorney in advance based on that consultation and my understanding of North Dakota conflict of interest law. I do not believe this constitutes a conflict of interest requiring recusal. With that said, I wanted to disclose it for transparency, and I'll pause to see if any of the board members have any questions or concerns. Okay. All right, hearing none, we'll proceed.
Good morning, board members. My name is Nicole Crutchfield. I'm the planning director at the city here. With me today, we have Sean Radnick from the building official, and then we have Ian McLean, our city attorney, and then Mark Williams and Kim Citrowski, both from the planning department. I'll do a quick or brief overview of the items that are in your packet today, along with a few other additional exhibits for reference in case needed for discussion. So in front of us today, just as a reminder, we're here because of an appeal of an administrative decision. As the planning director, it's my decision that was potentially in question. And the appeals process outlined in the Land Development Code 2009-16. And just as a quick overview, the Board of Adjustment does grant administrative officials' decision a presumption of correctness. The burden of persuasion of error is on the appellant. The Board of Adjustment may reverse or affirm wholly or partly, or may modify the decision being appealed. The appeal may be sustained only upon finding by the board that the administrative official erred. And then a concurring vote of 4 members is required to reverse any of the decisions of any administrative official. So today in front of us, the appeal of the decision is to not schedule a proceeding of an appeal of an administrative decision application. The basis for this determination was that the appellant lacked authority to appeal the permits issued to a different property. The property in question of the building permit is at 4550 42nd Street South, and the appellant is Horizons Holding LLP, the property owner of 3900 Great Plains Drive South. Both parties are here today for presentation of materials and to answer any questions. The appeal regarding the building permits and components of the building permit would be considered in a different appeal based on the current application. So the question before you today is, did staff err on its determination to not schedule a proceeding for the original appeal of an administrative decision application from Corey Kallstrom on behalf of Horizons Holdings LLP, the owner of 3900 Great Plains Drive? That appeal was filed on November 6, 2025, and basing the determination that the appellant is not an authorized party to the appeal, to appeal the permits granted at 4550 42nd Street South. So there are many details of this application, and that we're glad to review any of them with you as you have questions. The relevant facts that we used as part of this case is on November 6, 2025, the original application to appeal an administrative decision of issuance of the building permit on October 17th was submitted regarding 4550 42nd Street. We're going to call this appeal number 1 for sake of clarity. An email dated November 14th outlining the staff decision, which indicated the applicant did not have authority to appeal the building permit since the appellant was not the owner, as referenced to section 200901A. The application to appeal an administrative decision to not schedule a proceeding was submitted November 14th. We're going to call this appeal number 2, and the hearing today is solely on appeal number 2. We certainly understand there's questions regarding the original appeal and the building permit that you may have for discussion here, and which is why we have Ian with us today to help clarify as we, kind of shift between discussion points. So just as a reminder, the provisions of the code that we're using, I won't read this to you, but you have this in your packet, and it's referencing the authority to file applications. This all sits within Article 2009, which sits as a body of work that we use in sequence as we make decisions. And I will point that the appeals of the applications under the Land Development Code are subject to this authority as it sits. There's also the relevant code related to appeal of the administrative decision process as that's laid out in the Land Development Code, and that's section 2009-16. Appeals of administrative decisions and related to elements in the Land Development Code, and the right to appeal of the administrative decision might be filed by any person aggrieved or by an officer, department, board, affected by any decision of the administrative officer. We certainly understand that there are some property ownership and questions and easements in play, and there may be a grievance, but the appeals may only be filed by a person with legal authority to take action sought for this board. The board does not adjudicate private property or easement disputes. So a little background, just some case history, if you will, to help lay out the order of proceedings. The subject property, which is the black line where it's labeled Horizons Holding, one of the clarifying elements is it's not defined as a legal lot under the Land Development Code. It is conveyed through a warranty deed recorded in November 97, and it sits within the Great Plains Software Edition plat, also recorded in May 1997. The applicant's property is located at 3900 Great Plains Drive South, and it is zoned general office. So a little bit of the history. So 3900 Great Plains building permit was issued in 1997. The 4550 42nd Street Commons building permit was issued in 2009. You may ask, how do these lines cross a building permit? And under the Land Development Code, when under initial ownership, there's a provision in the words defined section of the Land Development Code that allows the staff to review this as a unified development to meet the Land Development Code's related dimensional standards. So you can think of this as a campus. Those types of provisions are how we use the Land Development Code in these situations. So other relevant case items that are in your packet, just to identify, was the warranty deed to create the parcel of conveyance in 1997. There are several different easements that are within your packet exhibits, and these are developed to convey responsibilities related to building connections, building boundaries, and is coordinated between the landowners. There's a blanket easement for agreement of utilities. There's building connections that are temporary easements, and then there's building easements that are perpetual, and then there's the lease agreement between the two parties. Their current construction permits are related to, in our opinion, the current construction permits are related to the business matters to carry out the lease and easement business. And as mentioned earlier, the original building permits saw the property as one lot and permitted through provisions of a unified development standards. So just to summarize here, the land conveyed through the warranty deed is not a platted lot, and the sections as it is defined and recorded to meet subdivision regulations. So that's referenced under the building permit section 2009-13, and then the words defined as 20-1202. The recorded easements as shown through the included exhibits are private matters between landowners, and the easements and warranty deeds ascertain ownership transactions, lease transactions, and other private property contractual agreements. The owner at 3900 Great Plains Drive is not the same owner or have ownership rights to the property at 4550 42nd Street. Therefore, they do not have the authority to file an appeal of the building or permit issued at 4550 42nd Street. So for reference of the exhibits, I do have the plats related. This is the plat reference. So the one large lot there is the combined parcels in question. And this is from our GIS, just to show how the orange line here, if you can see that here, that's labeled parcel, is the deeded tract as it sits with the building envelopes. And then the remaining where Vista and some of the other buildings sit on that campus crosses over into another plat that was in 1999, Prairie Tech Edition. And then just for exhibits, for reference, if you need them, we have a couple excerpts from the building permit itself, if you want to have those referenced in discussion today. And then just as a quick summary on the timeline, what we're talking about is a sequence of events and conversations that you'll see correspondence, quite a bit of correspondence in your packet. And on October 17th, a building permit was issued. 1106, the appeal number 1. 1114, the staff decision that was portrayed through an email that's in your packet. And then the appeal number 2. And then the hearing today is solely on appeal number 2. So with that, that concludes staff's presentation. I might ask if Sean has anything else you'd like to add. And we're here to answer any questions. And again, we have both parties here for who I'm sure will want to speak.
Thanks, Nicole. Any questions for staff at this time? None? Contemplating? Okay. All right, no questions at this time, so if the applicant would like to speak, this is your opportunity.
Good morning. My name is Corey Kallstrom, and I'm here on behalf of Horizon Holdings LLP. This appeal is regarding the issuance of a building permit issued to HOK and Gertz Construction Services on behalf of Microsoft Corporation for the building located at 4550 42nd Street South, which I'll refer to as the Commons Building. And Horizon Holdings LLP is the owner of the City of Fargo parcel 01501000200100, on which sits the Horizon Building, and importantly, a portion of the Commons Building. And I'll refer to that parcel as the Horizon lot. I just would like to talk a little bit about the city's presentation and their determination that the lot created by deed in 1997 is not a legal lot, and I think there may be some confusion or error on behalf of the city with respect to that position. The city code, the land development code, explicitly contemplates that lots created prior to February 27th, 1998 are considered non-conforming lots and buildable lots under the land development code. For whatever reason, and we haven't really we haven't ever been told how they reached the position that that lot is not a legal lot, but it seems that a lot of the issues kind of tie into that question. So there's a memo that was sent out by Nicole Crutchfield that explicitly states that lots created prior to February 27th, 1998 are legal lots. There's a copy of the deed in the packet. showing when the property was deeded from Great Plains Software to IREIT that is clearly prior to that date, so prior to the subdivision requirements in the Land Development Code. And so we think that as an initial matter, that's one of the first errors as part of this process that was made by city staff. So I would also like to lay out a little bit of the background on what's happened with the properties over the last 28 years and how we find ourselves in the situation we have today. So the Horizon building was the original Great Plains Software building. It was built in 1997 on a lot that was deeded specifically for that purpose from Great Plains Software to IREIT. Great Plains Software kept the remainder of the property. Shortly thereafter, in about 2000, the building to the north that you can see on the map there, which is called the Vista Building, was built. When that building was built by Great Plains Software, they went through the proper process, subdivided the lot, and built that building on what's now known as Lot 1, Block 1 of the Vista Edition. After that, Great Plains was sold to Microsoft Corporation, who took over all the real estate assets of Great Plains, and including the lease on the Horizon building. In 2007, Microsoft undertook an expansion project, building the Commons building and the Visions building, which are located to the west of the Horizon building. Now, early plans of that Commons building contemplated that building entirely upon the property owned by Microsoft, with appropriate setbacks. And you can even see the angle of the building tracks the lot line. However, at some point in the design process, Microsoft elected to completely ignore the property line and build the Commons building partially onto the Horizon parcel, encroaching approximately 20 feet at its farthest point and containing an area of approximately 1,167 square feet. Also, for unknown reasons, Microsoft did not elect to subdivide the property in order to create a buildable lot as required by the Land Development Code, nor provide a site plan to the city that showed the lot line separating the Microsoft property from the Horizon parcel. This encroachment was discovered in 2013, and an easement was executed granting Microsoft an easement for the maintenance, repair, use, and occupancy of the portion of the Commons building in the Commons building easement area. Now, as Microsoft has drastically reduced its headcount in Fargo, Microsoft has elected to terminate its lease on the Horizon building and has applied for permits in order to separate the two buildings as required by the terms of the lease and the 2013 easement agreement. As the neighboring property owner and the owner of the land on which a portion of the Commons building has been built, we are concerned that the construction contemplated by Microsoft does not comply with either the Land Development Code or the Building Code, and accordingly we have appealed the issuance of the permit. The zoning administrator of the city of Fargo denied our appeal, and we promptly appealed that decision, which is the purpose of today's hearing. So you received a 150-page packet of materials related to this hearing, and it's important to understand the only issue before the board today is whether or not Horizon Holdings is permitted to appeal the decision of the city official to issue the building permit. Decisions on whether or not the plans comply with the requirements of the Building Code or Land Development Code will need to be made at a future hearing on that matter. Now, there is a little bit of a chicken and egg problem, as some of the arguments are that the alleged non-compliance with the code makes us an aggrieved party, as our rights are impaired by such non-compliance. Microsoft, through its counsel, in its letter dated December 9th, spends a lot of time arguing that the plans do not violate the code, and accordingly, we are not an aggrieved party. While we disagree with much of his interpretation of the code, this hearing is not the time to decide that issue. So I think it makes the most sense for the board to assume that our allegations are correct, because doing otherwise would greatly expand the scope of this hearing beyond what was permitted by the zoning administrator in granting us this appeal hearing. This leaves us the only question before the board is whether Horizon Holdings is an authorized party to appeal the issuance of the permit. In the staff report that's included in the packet, the city cites section 20-901 of the Land Development Code as determinative that Horizon Holdings is not an authorized party to appeal the issuance permit. However, a plain reading of that section makes it clear that the language highlighted in the packet applies to who is authorized to apply for development review or approval under the Land Development Code. The relevant provision reads, an application for development review or approval under this Land Development Code must be filed by the person having legal authority to take action in accordance with the approval sought. Remarkably, the entire justification for the zoning commissioner to deny us our appeal relies on a completely irrelevant provision from the Land Development Code. Now, they discussed a little bit today section 20-0916, which is the provision that deals with appeals, and I provided you a copy of that code section. As an initial matter, applying the wrong code section and making the decision to deny our appeal is exactly the type of error that is contemplated by Section A of Section 20-0916, which provides that the Board of Adjustments is authorized to hear and decide appeals where it is alleged that there is an error in any order, requirement, decision, or determination made by an administrative official of the city. Applying the wrong standard in determining to reject our appeal should be sufficient grounds to reverse the decision of the zoning administrator to deny bringing our original appeal to the Board of Adjustment. However, as Microsoft has also provided its thoughts on why we should not be allowed to bring our appeal, I would like to also explain why, as a matter of right, we are entitled to have our original appeal heard by the Board of Adjustment. As discussed before, paragraph A of section 20-0916 authorizes the Board of Adjustment to hear and decide appeals where it is alleged that there is an error in any order, requirement, decision, or determination made by an administrative official of the city in the administration or enforcement of the Land Development Code. In this case, we have alleged that the inspection director of the city has made an error in determining that the plans submitted by Microsoft comply with the Land Development Code and the Building Code, and accordingly, the inspection director was prohibited from issuing the permit. This is exactly the type of decision that is ripe for appeal to this Board of Adjustment. Microsoft's first objection to our appeal is that it is untimely and cites section 20-0903.b of the Land Development Code. And that provision states, for matters that do not require a public hearing, the date of the decision shall be the date indicated on the notice that is mailed to the applicant by the city planner or zoning administrator, and requires that appeals of such final decisions must be filed within 10 days of the date of the decision. Horizon Holdings was not an applicant and has never received a notice from the city of Fargo that the permit had been issued. The time provision in section 20-0903.b only applies to applicants appealing denial of their building permit. In fact, Horizon Holdings had been told by Sean Rodnick that he would not issue the permit without first notifying Horizon Holdings. On October 17th, Horizon Holdings received an email from the city attorney, Nancy Morris, that the building application was still under review. Minutes later, without any notification to Horizon Holdings, the city of Fargo issued the building permit to Microsoft. When we get into the actual section dealing with appeals, section 20-0916, paragraph D, is titled Time of Filing Appeal. And under that code provision, there is no time. It merely states that the appeals of administrative decisions shall be filed with the zoning administrator. And as a practical matter, enforcing a 10-day requirement on third parties from the time that the permit is issued would be unreasonable. The entire point of the appeals process is to correct clear errors by city officials. A neighbor may not even know a permit's been filed, let alone approved. And such interpretation would basically remove any protections to third parties to access the appeals process as contemplated by the Land Development Code. Further, Section B provides that appeals of administrative decisions may be filed by any person aggrieved by any decision of the administrative officer. The term aggrieved is not defined in the Land Development Code, but has been interpreted by the North Dakota Supreme Court as one who has some legal interest that may be enlarged or diminished by the appealed decision, and such party must be injured in some manner. That is, the decision must enlarge or diminish a party's interest. Further, in Minn Kota Ag Products versus the North Dakota Public Service Commissioner, it is immaterial how slight or substantial this grievance is for a party to be aggrieved. While the city does not analyze the question, Microsoft has argued that Horizon Holdings is not an aggrieved party. So to me, the only question before today is whether Horizon Holdings was aggrieved by the issuance of the permit. And we think it is clear in 4 ways. The building plans approved by Microsoft contemplate a imaginary lot line, which is drawn for fire separation distance between buildings on the same parcel. Originally, Microsoft had requested that we consent to a boundary line adjustment, moving the lot line to their preferred location, and we made it clear that to both the City of Fargo and Microsoft that we were unwilling to do so. So over our objection, the city issued the permit using that imaginary lot line. Microsoft's argument that we are not injured by the creation of the imaginary lot line relies upon an interpretation that it is only used for compliance with Microsoft's building. However, the code makes it clear that that imaginary lot line binds both our building, the Horizon building, and the Commons building. And it effectively creates a no-build zone for Horizon Holdings on its own property solely due to the actions of Microsoft and the permit that was issued by the city. By allowing the permit as issued to stand, the Board of Adjustments would be allowing a neighboring property owner to complete a construction project that permanently impairs its neighboring parcel in a way that is completely incompatible with the building code, the land development code, and good governance. Additionally, the permit authorizes construction activity on property owned by Horizon Holdings without its consent and over its objection. Microsoft has claimed that it's restoring the exterior wall vacated by the Commons connections. However, there is no wall to restore. The Commons building was never a standalone building, and Microsoft is completing a new foundation at wall that must be built in compliance with the fire code. And at least a portion of that new foundation and wall are being built on property owned by Horizon Holdings and not subject to the Commons building easement. Clearly, Horizon Holdings is injured by the city allowing a neighbor to construct improvements that fail to comply with all applicable codes on its property without its consent, and any argument to the contrary must fail. I'd also like to point out, as part of the permit, Microsoft has installed power lines across Horizon Holdings property, even after Horizon Holdings directed Microsoft not to do so. This work was authorized under the permit that we are appealing, and the granting of the permit and authorization by the city to complete such work has injured Horizon Holdings. Microsoft alleges that we are providing consent to the work conducted on the Commons building on the Horizon parcel, which is false. We did consent to the demo permit, but the demo permit did not contain any construction plans. We consented to the removal of the connections and restoration work associated with the enclosure and exterior finishes of the existing building facades. This limited scope of work most certainly does not include the construction of a new foundation and exterior wall on our property or the installation of power feeds across our property. It is clear that by granting the permit which authorized Microsoft to conduct construction on our property without our consent has injured Horizon Holdings, which makes Horizon Holdings an aggrieved party for purposes of having the right to appeal. Tying into the fire separation distance in the imaginary lot line, Microsoft argues that Horizon Holdings has no standing to appeal that violation. Now, while it may be true that Horizon Holdings would not be able to appeal a provision of the fire code that solely impacts the Commons building, the entire point of the fire separation distance requirements are to protect the neighboring property owners. And the failure of the city to enforce those provisions and require a proper fire separation distance negatively impacts the Horizon Holdings as it removes the protections that they were afforded by a proper implementation of the fire code. There are numerous provisions of the building codes that have an impact on neighboring property owners, such as height restrictions, setbacks, landscaping requirements, not allowing neighboring property owners to appeal the issuance of a building permit based on such violations is incongruous with the appeal process created by the Land Development Code and contrary to the public interest. Mistakes happen, and the appeal process is designed so that those impacted by such mistakes have an opportunity to be heard by their elected officials and have such grievances resolved by those officials. Microsoft's interpretation of the appeal process would leave residents unable to appeal the issuance of a permit that directly impacts their property and was issued in error. As an example, your neighbor could be issued a permit to build on the property line in violation of the setback requirements. And even if you discovered such violation, you would be without any recourse to appeal that decision. Clearly, that is not the process envisioned by the Land Development Code. As the concept of fire separation distance is designed to protect neighboring property owners, the granting of the permit to Microsoft, even though the construction plans violate such requirements, has resulted in an injury to Horizon Holdings, which makes Horizon Holdings an aggrieved party for purposes of having the right to appeal. It's also important to point out that Horizon Holdings is not only a third party in this dispute. It is the record owner of the portion of the Commons building and is directly impacted by the decision of the city to issue the permit. The city has repeatedly stated that it does not recognize the easement for purposes of determining the owner of the Commons building on the Horizon parcel. Both the Land Development Code and the International Building Code place compliance with such codes on the owner. As the plans contemplated by the permit do not comply with either code, Horizon Holdings could face potential penalties related to such work, and this is an injury as it impacts the marketability of the property owned by Horizon Holdings, and it is in our interest to have all outstanding code noncompliance corrected prior to the issuance of any permit that expands the Commons buildings. We think it is clear that the Commons building has never complied with either the International Building Code or the Land Development Code. Neither code permits a building to be built across a lot line. For unknown reasons, Microsoft decided to ignore the lot line when they built the Commons building. And now that the issue has been discovered by the City of Fargo, instead of requiring Microsoft to resolve the issue, it is merely kicking the can down the road. The International Building Code is clear that in the event a building does not have a legal existence, corrective action will be needed to bring the structure into compliance with the regulations of the jurisdiction at the time the building was built. And the Land Development Code prohibits building officials from issuing a building permit unless the plans, specifications, and intended use of such buildings or structures or part thereof conform in all respects to the provisions of the Land Development Code and the Building Code. Each of these four issues on their own would be sufficient to grant Horizon Holdings the right to appeal the decision of the city to issue Microsoft the building permit. It is clear that Horizon Holdings has been injured by the issuance of a permit in that a no-build zone has been created on its property without its consent. Work has been authorized by the permit on the Horizon parcel without its consent, including the installation of underground electrical lines, that the construction work contemplated by Microsoft has failed to comply with fire separation distance requirements, which are specifically designed to protect neighboring property owners, and the permit allows continued non-conformation with the Building Code and Land Development Code, which makes Horizon Holdings potentially liable for fines and penalties, as well as reduces the marketability of the Horizon parcel. For those reasons, we think you should sustain our appeal and grant us a hearing on the original appeal to determine whether or not the building permit was issued in error. And I'm happy to answer any questions or provide any background.
I guess I have one question for you. Could you, amongst all that, you went through your argument for the timeliness claim. Could you please just briefly restate that?
So if we look at the language in section 20-0903.b, it only applies to, so it's, I don't have the whole thing, but for matters that do not require a public hearing, so the issuance of the building permit did not require a public hearing, the date of the decision shall be the date indicated on the notice that is mailed to the applicant by city planner or zoning administrator. So that provision only applies to the applicant, right? Horizon Holdings was not the applicant. Microsoft was the applicant. There was no notice that was sent that the permit was issued. In fact, we had been told that we would receive notice prior to the permit being issued, which we did not receive. And just from a broader perspective, the third-party appeal rights in section 916 are broader than the rights to appeal under section 903. So 903 deals with the process of, I asked for a variance, all of those different things, and it provides that timeline. But it doesn't make sense to hold some third party liable to know about something that they haven't been informed of.
Okay, no, that's good. Thank you. Appreciate that. Now I'm going to ask Ian to comment on that to see if the city agrees with that interpretation, let's say.
So, 200903.b, as we talked about, is an appeal of an administrative decision filed within 10 days of the decision. So that'd be 10 days of October 17th. Obviously, the city's position is we're here about appeal number 2 and the standing, but if we went to the timeliness issue, I think it sort of carries into standing, because what you're hearing from Horizon today is that we should be able to appeal that basically that 2009-16 basically allows a freestanding invitation for any third party to litigate when they're an aggrieved party. And if we don't apply the 10-day deadline to them, then I don't know what that deadline would be. Are they going to appeal within 6 years, 10 years? So I do think the city's position, without speaking to Nicole, would be that the 10-day deadline does apply.
Okay, thank you.
If I could add, I'd also like to point out that within that 10 days, we had provided a fairly lengthy memorandum to the city laying out our position. And only once we received confirmation that they weren't going to reopen the case on November 6th is when the first decision to us was November 6th, where they said they were not going to reopen the issuance of the permit. So Horizon Holdings was attempting to work through city staff, right, to reach a resolution, and only on November 6th were we told that this avenue is closed, right? The city staff was considering our comments. Our comments were provided within 10 days. And it was an ongoing live dispute with the city. And then on November 6th, we received notification from the city basically that, we're done looking at this. And that's when we chose to appeal to the administrative or the Board of Adjustments. And I think that's important because we should be able to work through the city staff to reach resolution, to try and solve problems, rather than immediately there's any kind of adverse decision that has to go to the Board of Adjustment. It's not the process contemplated by section 916. There's a reason that the provision regarding time of appeals in section 916D is vacant. There's nothing there. It doesn't have a time of appeals because there's times when things cannot be discovered until a later date. So I think I would just caution the Board of Adjustment on accepting the city's rationale, because then the number of appeals to the Board of Adjustment necessarily skyrockets. If people are like, well, I can't even ask the city to clarify something, I immediately have to go to the Board of Adjustment. And that's just not good public policy, and it's not supported by the code.
But that is kind of the process. It's like, if you feel that there was an error, you have 10 days to file that appeal. You can file it prior to the 10 days and then work through it with staff and then, recall your appeal. But the 10 days is in there for a reason, in my opinion, and that's so that things like this don't drag on forever. If somebody gets issued a building permit, they start construction, and 30 days later, somebody says, oh, I object to this. It's like, now they're 30 days into construction, and they have to stop. It's like,
I think it's important to understand that this only applies to clear errors, right? So if my neighbor builds their house 50 feet tall, I have no right to sue them to enforce the building code, right? My only right is to appeal to the city to enforce the building code. And I may not know about my neighbor and their construction project until they start construction. So there's plenty of safeguards in the code as it's drafted, to protect people, because it only protects people, it only applies if there is a clear error. And I think it's bad public policy to try and impose a time limit on someone who's not party to the process, particularly a 10-day time limit when that's not found in section 916. And again, the language only applies to the applicant. Date indicated on the notice that is mailed to the applicant. We weren't the applicant. We received no notice. So there is no clock that was started with respect to this 10-day period.
okay, thank you. I'll yield if anyone else has a question first.
I have a question about you being notified and agreeing to a demolition permit. What was the timing of that? When did you agree to that?
Yeah, so our understanding is Microsoft originally submitted permits early in the year. They approached us in late August regarding the issue surrounding the lot line and requesting us to move the lot line. And then we discovered that the original demolition permit had been issued in Horizon Holdings' name. And we hadn't had a chance to review anything related to that. So we asked the city to just, hey, let us take a look at this. Microsoft had requested some work that they wanted to complete under the plan, which we said was fine. We just wanted to make sure at that point that what was happening with the Horizon building was what needed to be done, right? So we wanted to make sure the materials were correct, the windows were correct, things were going in the right position. There was no building plans on the demo permit. I had made a request to Mr. Radnick for building plans related to the demo permit, and he confirmed that they don't get building plans for demo permit. And then shortly after we had a chance to review everything, we provided consent to proceed on the demolition plan.
Say that last thing again.
To proceed with the demolition plan.
Yes.
So that would have been like in the middle of September, I believe.
When you understood the extent of the demolition? I'm not.
So, okay, yeah, so the demolition plan was removing the connections and repairing our building, and then some other work. And so, once we agreed that the work on the Horizon building was satisfactory, we granted our permission to issue that permit.
And then did you also agree to the imaginary property line, that relocation?
No, that was complete, that was covered by the separate permit, that's the basis of this appeal. And we made it clear throughout the process that we were not agreeing to the imaginary lot line.
But you were agreeing to some modification to the exterior of the
Yeah,
Holdings
I don't know
building?
if this is gonna work, but it may be helpful to. So you guys have a copy of this, but
We do.
let me get my bearings. This building this building here is the Horizon building. This building is the Commons building. Okay? So there was connections coming here that we agreed to have removed. The line's about right here where the easement is. And so basically, all we consented to was removing these connections and replacing the windows and doors in our building. And that imaginary lot line is where they wanted to put they wanted us to move the lot line, which we're not willing to do so. And part of the reason for that is our building was built specifically on the amount of land for our building. So the setbacks are fairly narrow, and Microsoft's already encroached 20 feet onto that, and we're just not in a position to give up any more land.
Can you point out what the blue line means? That's the imaginary line, and where our property line actually is, and how their property was built over our property.
Yeah, so here's the property line, right? And here you can see where the encroachment is. And this is where they wanted to move the imaginary property line, which is for purposes of fire separation distance. And basically, it restricts our ability to expand our building in that direction.
I see Sean's at the podium. There's something you want to add?
I just wanted to explain the imaginary property line a little bit. In the building code, when we're looking at buildings on the same lot, we're looking at an imaginary property line between them for fire separation distances. It has to be at least 10 feet. And as you can see by the graphic that they have up here, they have 12 feet, 7 inches and a quarter, and 12 feet, 2 inches and a quarter. So they met the provisions of the building code at that point. That's why the fictitious or the blue property line on there, the imaginary one, is there. It's just for fire separation distances when we're issuing the permits.
Thanks, Sean. Sean, I had a question, one more question for you while you're up there. So I believe they're claiming that the improvements that Microsoft is doing under the permit do not fall within the easement that they have. Do you agree with that?
So the way we're looking at this, the way that we have to look at this one, because of the meets and bounds property line that they have and the easement that they have and stuff, we look at those as kind of like a covenant. It's a self-imposed restriction, nothing that we can use for building permit purposes. So when we're looking at it, we're looking at this, these are two buildings on the same parcel of land or lot in our estimation, and for issuing of the building permit and stuff, it's a civil matter between those two about whatever is happening between the over the red line. For us, we don't look at that as a legally platted lot line, although it may be a legal lot line for other purposes outside of city business. For city business, it's not a lot line that we look at.
So basically, if I understand what you said correctly, kind of boils down to Microsoft thinks they're building within their rights. Verizon feels that they're not. Correct.
Yes.
So it's really an argument about
Yeah,
who's
it's a-
right on the easement.
Yeah, it's a civil dispute between those two property owners about that meets and bounds lot line.
Right. Thank you.
So to clarify, depending upon, which I understand it's a separate civil matter, who is determined the landowner of the easement that was agreed to be abandoned in the lease agreement back to Horizons? Whomever's determined to be the landowner of that, would they have a right to appeal construction on their property?
Before this board, no. If we're looking at a building permit issuance, that would not be this board that would determine anything on the building permit at that point.
Are there any other questions for staff or the applicant?
Could the city speak to Mr. Kallstrom's claim related to the, 2000, or 1997 warranty deed and the, the 18 land development code that talked about if it was conforming before and after that date? And I got the dates wrong, but I think you understand what I mean.
1998, I think is
Yeah.
the date.
Yes, so in staff's opinion, that's immaterial. The requirement to have a subdivided lot, a platted lot, rests with the Century Code, and the point of the provision in the land development code is related to dimensional standards related to platted lots. So we're using the definition in the land development code as a buildable lot versus not a buildable lot. The 1997 provision is about if you platted a lot in prior to 97 and related to the dimensional standards of that lot and as it applies to the new zoning code as it were to be applied.
If I could just, if I could just talk on that.
Just a second.
Okay.
So essentially, I mean, I don't know if this is what they're arguing or not, but one might think that after 1998, if it wasn't previously a platted lot, it would become a platted lot, and basically what you're saying is that's not true, right? There's still it's still not a platted lot, even though
Correct.
there's a meets and bounds description that.
Correct.
Carves
You know,
it
the
off.
conveyance of land is one thing. The defining a buildable lot in relation to the land development standards is a different thing.
Okay, thank you. Okay. go ahead.
Yeah, I mean, I would just say, I think that's clearly an error. It's not the language in the code. We own dozens of properties throughout Fargo with meets and bounds descriptions. Basically, the entirety of Fargo developed before 1998 used meets and bounds descriptions. I think you could probably look at City Hall and it might even be on meets and bounds descriptions.
But that doesn't make it a platted lot, is what we're saying.
But they're removing protections on Horizon Holdings lot because it's not a platted lot. And if that's the case, this is a massive issue on buildings all throughout town. So the position of the city is that since it's not a legal lot platted, there's no property line. Because that's how they got around the fire separation distance on the property line. Basically, they're saying there is no lot line, and it would create chaos throughout the city of Fargo. I mean, I can think of 15 properties that we have that are on meets and bounds descriptions. So,
But
there's-
you keep like forgetting that there's an easement granted to Microsoft to be there. They have a permanent easement to have their building where it currently sits, so.
That is correct, partially, because there's part of the building that they're trying to keep not on our lot, but that's immaterial. The issue is, does it comply with the building code? And even if they have an easement, how do they get to take an additional 12 feet of land outside of the easement? I mean, from a fundamental perspective, it's our property. And if they want to try and reform the easement, they could certainly go to the court and do so. But the city shouldn't be in the permission of granting a permit, assuming that their fairly spurious legal argument is going to prevail.
So to the city, I guess out of curiosity, could the Horizons building equally submit for a permit for construction and go over the property line in the other direction? Is that what they could do the same?
Yeah, I guess for the purposes of the land development code, it's one lot, one block.
Sure.
I'm still a little confused here. Ultimately, with Microsoft shrinking their campus, they're trying to sell off some buildings or whatever they're doing. What would be, is this fight between you and the Microsoft, does this need to be settled? Do you have to file suit against Microsoft to resolve this? Because everybody here thinks, say that everything was issued in accordance to the way that property was developed. And timeline-wise, do you have to proceed? I mean, are you thinking you're going to end up in a suit against the Microsoft people?
I mean, we haven't determined how we're going to proceed. I mean, we're hopeful, as always, that we'll be able to reach a resolution. Yeah, our request for the cities to enforce the code. I think it's important to understand that Microsoft, and Microsoft alone, made the decision to treat this as a unified property when it shouldn't have. There was no provision in the code that allows a building to go across a property line onto a neighboring owner's parcel. And they've put themselves in the position that they're in. They're not the innocent party here.
Being that you own the Horizons property, or the,
Correct.
was it a mistake on your part to not resolve this when it was separated?
Well, it wasn't separated, right? The Horizon building was built first, if that's what you're getting at.
Well,
So the lot was created, the Horizon building was built, and it existed, and then the Commons building, was built onto the lot.
but at one point, everything was a Microsoft campus.
Well, IREIT built the building for Great Plains, and then Horizon Holdings, and Microsoft completed the construction work in 2008 and didn't get an easement until 2013. So Microsoft basically just went ahead and did it, and then it was discovered that there was an encroachment. They granted an easement to Microsoft as is, where is. And now as it's being separated, we think it should be required to comply with the building code. And again, that's the issue for appeal later. The issue today is whether we even have a right to have that appeal, because the granting of the permit has injured Horizon Holdings.
I heard that the administrative staff based their decision on the easement and the language of that, because that does describe how changes would be made to the property. And there is some text here about easement relocation and what happens with that easement. And it says Great Plains reserves the right at any time in the future to relocate or reconfigure the path of any easement herein granted without IREIT's consent. Provided, however, that in exercising any such right, Great Plains shall pay for all costs to physically locate all equipment, lines, or facilities lying within the easement, and the route of the new easement must be substantially the same quality and utility as the previous route, and otherwise not affect the quality or quantity of service of such utility. It goes on, but it sounds like IREIT, they're not required to get IREIT's consent.
Okay, so that easement, I believe the 1999 easement, which was put in place when the Horizon building was built, and it solely relates to the utilities serving the Horizon building. So, again, since IREIT had bought a parcel that was surrounded by land owned by Great Plains, it needed that easement to get utilities into the building. So that deals with that specific issue, not really anything to do with the Commons building, which was
Not modification of the Commons building.
correct. Because that was prior to the Commons building being built, considered. That only benefits what's now the Horizon parcel.
Right, are there any other questions or comments?
I was wondering if the city could summarize one more time who is allowed to make the appeal. I know there's a whole page with all the language. And how that would relate to property owners or landowners.
Well, I think for our purposes today, we are basing our decision on the highlighted section in 2009-01 and the person having legal authority in accordance with the approval sought, unless otherwise expressly stated, that person is presumed to be the record owner, purchaser, or under a sale from the record owner, or the duly authorized agent from the record owner. And typically, when we're looking for a record owner, we want the owner, if they're having an agent, it's an assigned agent that they give us a piece of paper that indicates as such.
And so in a scenario in such that we're in where it's under dispute who the owner is, how are we able to determine who's allowed to make an appeal?
Well, I don't know if we are in dispute of who the owner is in terms of this parcel of land in regards to the Microsoft, the Microsoft building or the Commons building. And so related to the permit holder and the owner of the permit holder.
So I guess, are you saying that the east side of the property line is also owned by Microsoft?
Yeah, I'm saying in terms of the building permit holder for the demo permit and for the appeal to hear the permit, the appeal to hear permit, appeal number 1, I'll start there. That permit holder is, that permit holder is the owners of 4550 42nd Street. The permit holder of, the only people authorized to file that appeal on the building permit in this case is 4550 42nd Street owner of the building permit. And so if there's a complaint or if there's judgment on if the permit was given or if there was a property line grievance, that's a different hearing and that's a finding for a later date. And that building permit appeal process, basically you would have to find that Sean erred in the review of the building permit application.
And that's a different appeal.
That's a different process, yeah. Maybe if you go through Corey, yeah.
Hi, I'm Patrick Vesey. I'm Horizon Holdings LLP. You had said something a minute ago on the property line, and you had stated that if we wanted to expand our building over the property line to whatever, that would be okay? That's what you just said? I just wanted to clarify that.
Well, I think we're...
Onto Microsoft's property, I want to clarify that. If we wanted to expand our building 40,000 square feet onto Microsoft's property, you said that would be fine.
I think what I would summarize is we're in a land ownership dispute, and most of the time, this isn't our first land ownership dispute, is required by, private discussions between parties. All we can use is the records that are filed and in place with us.
But you just said a minute ago that we could build over the property line. I just wanted to clarify that.
Again, we see this as one lot, one block. I think that might be what you're referencing.
So the answer is yes?
I'm not going to answer hypotheticals.
Okay.
We're not used to our meetings going this long, so I think this might be a good time for just a brief recess.
Yeah.
So we'll be in recess for, let's just say, 5 minutes. Thanks. Okay. All right, we'll resume the meeting. Were there any other questions for staff or the applicant, or are we ready for a motion and discussion?
I have one more question. I have one more question maybe for Nicole. If we are viewing this as one lot and one block, why wouldn't Horizon Holdings have the same rights as the Microsoft portion in being a authorized party to appeal?
I think, we're making the determination as the owner of the building permit that has the rights to appeal or not appeal.
So maybe just to make sure I understand it, the owner of the building permit is the only entity able to appeal that building permit. And so in theory, no one's going to appeal getting a building permit that they asked for. So really, it's just set up, the appeal process is set up for people who are applying for building permits and then are denied. They get 10 days to appeal the denial, because who's going to appeal getting what they want?
Yeah, so, I think in essence, probably the best way I can answer that is, in my 18 years here, this is the first building permit appeal we've seen, and so when it comes to the rights of the building permit holder, and, I don't want to project what it, I'm assessing, but, yeah, I see where you're going, but we stand by our position.
So nobody in this case, nobody has the right to appeal this then?
So I think the building permit appeal process is generally, I'm just going to say this in generalities, is if for some reason Sean were to deny a building permit, or the site plan permit review process were to deny a permit, you would want to have an appeal option for staff making an error in reviewing a building code item or a land development code item. And I will declare too, a building code issue is with the Board of Appeals, and a land development code issue is with the Board of Adjustment.
Yeah, and since this is essentially one lot, one block, there's no setbacks, there's no lot line setbacks involved here, right? So that's why, it's not a land development code issue, it would, if it's
It's much
anything,
like,
it's a
from a
building
staff perspective, sorry to interrupt you, from a staff perspective, it's kind of like a condo situation, right? And so the risks and responsibilities and, where does that duty lie with property owners and the regulating agency, and with the legalities of things.
Would you like to say something?
Good morning, good morning, Board. This is Robert Smith on behalf of Microsoft. First, I'd like to thank city staff for their continued effort to evaluate these permitting issues. We support staff's position concerning Horizon Holdings' appeal. The appeal pertains to underlying real estate disputes between Horizon and Microsoft. Microsoft has notified Horizon that is ending its long-term lease of the Horizon building and is currently engaged in restoration work, including removal of a connection between the Horizon building and the Commons building, approved under a previously issued permit supported by Horizon. There's a dispute concerning the amount of area covered by the perpetual easement that occupies the Commons building, and we are engaged with Horizon on ongoing negotiations on that issue. We agree that the city is not proper for the city to opine as a non-party considering that ongoing real estate dispute. Horizon's appeal is procedurally improper for at least 3 reasons. First, it is time barred. Any appeal to the board must be filed within 10 days. Horizon did not meet this deadline. It is an appeal of the building permits that were issued to Microsoft, and Horizon does not contend that the appeal was filed within 10 days. Regarding the section that Horizon cites, which is section 20.0903, It says, appeals of final decisions made pursuant to the procedure of this article must be filed within 10 days of the day of the decision. The article referenced is section 20.09. That includes the other section that they're discussing. It doesn't say applicants must file it within 10 days. It says any appeals must be filed within 10 days. Their decision is therefore time barred. Horizon argues that there's no limit to third parties filing appeals. This would create significant prejudice to applicants. And in fact, that is true here. Based on those validly issued building permits, Microsoft has already spent thousands of dollars in constructing the improvements, not just to make sure that it complies with its lease agreement to vacate the Horizon building on time, but also to make sure that its Commons building is improved enough so its operations can move over in a timely manner without interfering with operations. To reverse now would do undue prejudice to Microsoft. And again, this is a jurisdictional issue. It is black and white. Either they meet the 10 days or they don't. There's no discretion by the board that's granted under the code to ignore that issue. Horizon said that they filed a memorandum where they continued to work through things with the city. That's not the same thing as an appeal. The proper procedure, just like any applicant would be to file the appeal and continue to work through things if they need to with both Microsoft and the city. That was not done here. There is no right to say reconsideration under the code. It is a 10-day time frame, and then that's it. Mr. Kallstrom said that appeals will skyrocket if the interpretation is as it is stated in the code. We actually argue that the opposite is true. If you grant Horizon's position that there is no time bar, then a third party can file an appeal 6 months later, 6 years later, or in this case, over a decade later, when Horizon Holdings is arguing about the setback issue with a building that was finished in 2009. So there'd be no time bar on anybody coming forward to this board to argue about a building permit issuance. Secondly, there's no third-party right to appeal building permits to the board. The section that Mr. Kallstrom cites, section 20-0916, he reads the right to appeal, which is in subsection B, but I'd like to draw your attention to subsection A. It says the Board of Adjustment shall be authorized to hear and decide appeals, whereas alleged there is an error of any order, requirement, decision, or determination made by an administrative official of the city in the administration or enforcement of this land development code. As just stated by city staff, this is not an appeal of the land development code. This is an appeal of a building permit that was issued under Chapter 21, not Chapter 20, and has a different appeal process if they wanted to go ahead and appeal the building permits. This board only sits to hear appeals related to the land development code. Finally, Horizon does not have standing as an aggrieved party. As stated in our letter that was submitted to this board, that aggrieved party has defined terms under North Dakota law. It says, we said a person is factually aggrieved if the decision enlarges or diminishes that person's interest. A party lacks standing if it has only a nominal, formal, or technical interest in the action. A party must be injured in some manner. The party's interest must be immediately, directly, and adversely affected, and that effect that is contingent or indirect or that results merely in some possible remote consequence is insufficient. An appellant must establish they are aggrieved in fact to establish standing. In other words, it's not sufficient to just say that there is a hypothetical violation of the code. That's not sufficient to establish third-party standing. They actually have to show that there is some actual injury to that party. The only work to be performed in the area that extends onto Horizon's property under the challenge building permits is a small amount of interior work in a storage closet. Horizon has no argument as to how that work injures Horizon. The challenge permits do not allow any expansion of the Commons building, change or intensification of use, or any external modification that would impact Horizon. Horizon conflates the multiple permits that have been issued to Microsoft. Most of the work discussed in the appeal, including the restoration of exterior walls subject to fire code requirements, and the power relocation and foundations, was all approved under permit number 2507-44-REN. That's the demolition permit. That includes all the work that was done, that's proposed for the exterior walls on the Commons building, which makes sense. That permit deals with both the demolition of the connection and also the repair of not just the Horizon walls, but also the Commons walls to make sure there isn't a hole in the middle of those walls. Horizon acknowledged and supported and approved that in previous communications with the city. Horizon's fire code arguments do not pertain to the appealed permits, which almost entirely pertain to work performed exclusively on the Commons building property owned by Microsoft, but rather to the permit they actually supported and approved on the demolition permit. To be clear, Horizon was provided with full construction plans and walked the site with the site visit with Microsoft prior to that approval back in September. And you'll reference, if you look at our letter, the communication that was issued to the city. In fact, the city asked for a joint letter from both Microsoft and Horizon that they agreed to the work that was issued by the permits. And a joint letter submitted by both Microsoft and Horizon, they signed off on that work. So in other words, Horizon has waived the right to appeal any work associated with the demolition permits, which is the only work that would implicate fire code issues. As a practical matter, Microsoft's restoration work will improve fire access on Horizon's property through the removal of the connector that previously connected the Horizon and Commons buildings. Horizon's claims regarding setbacks are similarly time-barred. The Commons building has existed in its current location since 2009. Horizon has been fully aware of that building for over a decade. The portion of the Commons building extending onto the Horizon property was addressed in a 2013 easement, and Horizon has benefited by receiving money from that agreement since it purchased the property. The challenge permits do not extend or otherwise affect any setback from onto Horizon's property. Further, hypothetical conjecture regarding how the city's evaluation of fire code requirements for the Commons building improvements may impact Horizon at some future time, an unspecified impact, does not establish standing. Each application to the city is evaluated on its own merits. Speculation concerning adverse precedent does not establish standing. If that weren't true, anybody could come before this board and say, I don't like the board's decision, and all of a sudden, because that's precedent, that establishes standing to a third party. That's not how the city evaluates that under its own code, nor how North Dakota law evaluates standing for zoning board adjustment decisions. Microsoft has operated on its campus for over a decade, which has resulted in a source of gainful and significant employment and tax revenue for the city, with no interference or notice of violation from the city or concern raised by Horizon. Microsoft's work is critical to both restore the Horizon property, as contemplated in its lease, and move operations to the Commons building. Horizon's continued interference jeopardizes these efforts. It is paramount that Microsoft continue the construction approved in the permits so as not to face significant impacts to operations on its Fargo campus. Horizon's appeal represents an attempt to create leverage to force Microsoft into purchasing its property or paying additional funds to Horizon Holdings. We continue to work towards an amicable resolution of Horizon's concerns. However, Horizon has failed to provide any basis that would establish standing to challenge the 2 building permits before you today. Therefore, its appeal should be denied, and we support staff's decision. Thank you very much. I'm available for questions.
Thank you. You have a question?
Yeah, so you mentioned the being injured, how New Horizons is not injured. Could we show the plan where the building is getting expanded into the vacated easement area? I guess just, I'm not going to be able to put my finger on it because we've got 150 pages of documents. But I do know in there somewhere, it states that, again, the easement agreement, which is not up for discussion and property ownership. However, it does state that once Microsoft moves out, they'll tear down Tract B, is it? Yes, Tract B, and turn that back over, kind of give that easement back to New Horizons, and then they will continue in perpetuity to have Tract C. And so if I'm looking at things correctly, I would have expected to just see that the north end of the existing commons easement would get a wall, and then the other wall would go on the property line, but it looks like the green area is getting built on, which is part of Tract B, which in the lease agreement is getting vacated and turned back over to Horizons. So I'm just curious, in your mind, how that's not injuring Horizons
Sure.
to just decide to expand the easement?
Okay, to be clear, that's existing building. It's not an expansion. That
That's
green-
the connecting link on Track B.
That part in green is not actually, it's literally inside the Commons building. The exterior wall goes on the right-hand side there, so there's no expansion of the wall or the overall size of the Commons building.
So
Our-
in the current, like, when that was a connecting link, how does that tie through a storage room? Like, how did the connecting link work through that space?
Yeah, yes, there's a door that's sort of at the end of that right-hand side that connects to the connecting link.
So perhaps the documents that show the tracks are in error?
Yeah, Microsoft's position is that there was mutual mistake at the time of the 2013 easement, that the easement itself and surrounding circumstances clearly show that, remember, the Commons building was in existence at the time, and the Commons building hasn't changed since the 2013 easement. Microsoft's position, there was mutual mistake, as shown by the correspondence at the time, that that was intended to cover that full part of the Commons building, not the connector. And that's part of the underlying real estate dispute that we're currently negotiating with Horizon Holdings.
That Track C is actually larger than shown on the lease agreement and the Houston drawings, and Track B is smaller?
That's correct, that the area that's defined by the language of the easement as the Commons building easement actually should be the entire Commons building that was built at the time, and that the legal description of that was in there. So in other words, the only work that the permits before you would authorize in that green area is some minor carpentry in the existing storage closet.
And it is an existing storage closet?
That's correct. It'd be, I think there's a small store in there currently, so they are just going to be, removing one door and basically doing some interior work to change it from a small store area to a storage closet area. I'm sorry. Sure, go ahead. I know, but the closet does not exist today because they're closing the holes up, and then that closet is just going to be built. So yeah, the closet will be built inside there, but yeah, and they'll be removing an interior wall and the door. Again, our position is there hasn't been any allegation as to how that would injure Horizon, in fact.
No, I appreciate the clarification because the track documents prepared by Houston show different outlines, so it's hard to follow.
Understood.
Has time run out for Horizon Holdings to file a motion with the Board of Appeals?
Typically, you have 30 days after the official notice, so you have about 30 days after whatever the issuance of the permit would be. I think that was October 17th, so.
Anyone have any other questions, or is anyone ready to act? Is there more discussion?
My understanding is that this comes down to where the property line is, and how the city acted in response to the imaginary lot line to complete their review.
Yeah, I feel like this is obviously a very complex situation with a lot of history to it, but, I mean, the way my mind processes it is, there's a dispute over the easement, and that's what's driving all this. So, I mean, whether or not Horizon owns the property, doesn't own the property, doesn't seem like that's the issue. It seems like it's the easement, which we're not gonna make a ruling on the easement. It's gotta be between two attorneys and a judge, so. So with that in mind, if there's no, maybe I'll just make a motion and we can have a discussion about it. With that in mind, I would make a motion to affirm the staff's decision to affirm staff's decision not to schedule a proceeding at Board of Adjustments for consideration of the original application due to the fact that the appellant, and I'm going to change the suggested motion here, that the appellant does not have standing and their application was untimely under Fargo Municipal Code 20-09.
I second the motion.
All right, we have a second and a discussion, or second and a motion and a second. Is there any discussion? Okay, hearing none, please call the roll.
Wendell Dobb. Gunkelman.
Aye.
Polchinski.
Aye.
Orth.
Aye.
Love.
Aye. So the application for appeal has been denied. You have the ability to appeal to the city commission within 10 days. Okay. Next item is other business. We don't have any. So is there a motion to adjourn?
I'll motion to adjourn.
Second.
Okay, motion is second. All in favor signify by saying aye.
Aye.
We're adjourned. Thank you.